Hello, I'm Dr. Nan Zhang. I'm Associate Professor from China University of Political Science and Law. Today, in this short video, I'm going to introduce you the highlights in the latest development of Chinese patent law. So this is the outline. Firstly, I'm going to tell you what happened. Secondly, I'm going to tell you what's the most important change. And thirdly, I'm going to tell you my analysis and my understanding. Everything will be targeting on better protection of your patent right in China. So what happened? The first patent law of People's Republic of China was implemented in 1985. The First Amendment of Chinese patent law occurred in 1992. The Second Amendment of Chinese patent law occurred in 2000. The Third Amendment of Chinese patent law occurred in 2008. The Fourth Amendment of Chinese patent law occurred in 2020. So the amendment had been through 4 times in the last 36 years. So what is the most important change in Chinese patent law system? I think it's Article 71. Let's look at this article word by word, line by line. The amount of compensation for infringement of the patent right shall be determined according to the actual losses suffered by the right holder due to the infringement or the profits of the infringer due to the infringement. So firstly, we see how to determine your compensation. The first consideration is actually your losses. And the second consideration will be the profits of the infringer. Where the losses of the right holder or the profits obtained by the infringer are difficult to determine, it shall be reasonably determined by referring to the multiple of the royalty of the patent license. Here we need to notice, when you make a licensing contract with someone or some organization, you need to be very careful on how much license fee you're going to charge, because this fee will be a very important element in the future if your right is infringed. If the circumstances are serious in case of intentional infringement of the patent right, the amount of compensation may be determined at not less than 1 time, but not more than 5 times the amount determined in accordance with the above methods. Let's look at the next provision of Article 71. If the losses of the right holder, the profits obtained by the infringer, and the royalty for the patent license are difficult to determine, the People's Court may, based on the type of patent right, the nature and the circumstances of the infringement, determine to give compensation of not less than 30,000 yuan, but not more than 5 million yuan. You see the range of this compensation. And the next provision said the amount of compensation shall also include the reasonable expenses paid by the right holder to stop infringement. So from this article, we can see there is a big increase on the compensation, especially the punitive damage that will help with the right holder to protect the patent right in China. And this is really good news for both the domestic right holders and overseas right holders. And then we see the next provision of this article. In order to determine the amount of compensation, what can the People's Court do? The People's Court may order the infringer to provide the account books and the material related to the infringement if the right holder has tried his best to prove the amount of compensation, and the account books and materials related to the infringement are mainly in the possession of the infringer. If the infringer fails to provide false account books and material, the People's Court may determine the amount of compensation by references to the claim of the right holder and evidence provided. This is really useful. It gives the judicial power of the court when the evidences are very difficult to collect by the right holder. So, you see, this is a very good assistance for collecting evidence and to provide better reasoning in the court argument. So that's it. Thank you very much for your attention and your listening. I hope this short video will help you a lot in protect your patent right in China. Cheers.